All rise. Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We are here today on our case number 1CACV 170045 in the matter of the estate of Charles H. Evitt, or Evitt. I apologize. By saying it both ways, I've messed up at least once. Both sides are allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself because the clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if when you approach the microphone, you would give us your name and the name of your client. We've read the briefs and we've reviewed the record in the case. We've also discussed the appeal in our conference today before argument. So with that, you may proceed.
Thank you. Good morning. My name is Charles Van Cott, and I represent the appellant and the petitioner, Dr. Judith Evitt Thorne. The decedent, Charles Evitt, passed away in Wyoming on September 25, 2013. We're here because of a provision in his divorce settlement with Dr. Thorne that provided for an automatic payment to her of $150,000 from his estate should he predecease her, which is what happened. The trial court resolved the issue on summary judgment, finding the claim barred under Wyoming's non-claim or no-claim statute. Dr. Thorne timely filed a motion for a new trial that was also denied. I'm hoping, and before I go any further, I would like to take you up on the invitation to reserve some time, and I will try to keep 5 minutes if I can, but I understand I have to police that. Our appeal raises 3 issues. The first is that a genuine issue of material fact as to whether Dr. Thorne was a reasonably ascertainable creditor entitled to actual notice under both the Due Process Clause and Wyoming law. That issue precluded the summary judgment that was granted in this case.
What kind of facts are the minimum to give rise to a claim? Here, as I understand the record, there was a discussion between the decedent and his children long before his passing, saying, we're cool. I've done everything I need to do for her.
Your Honor, I would correct you in one respect. And yes, you zeroed in on the facts that we think give rise to the issue. But there's nothing in the record to indicate when that conversation occurred. At one point in the answering brief, they said that actually the letter my partner sent to bring the issue to their attention back in 2015 prompted her to recall these conversations.
Let's say it occurred a year before he died. What is it about that conversation? If the conversation is...
If they're discussing the claim or the possibility of the claim, even if he tells her that I've paid this, and again, recognizing the way you're supposed to look at a summary judgment.
Discussion of this particular claim or just in general, I don't owe her anything?
Well, they say that they discuss this claim, and they say that he said that I don't owe anything. It was paid, but it's the discussion that raises the issue, and we don't know when it occurred, and we have to sort of assume that it occurred. All of the inferences, the factual dispute. You have to resolve all of these things in our favor to make sense out of that question. And in fact, the due process argument actually adds an added component, an added thumb on that scale, because the Wyoming Supreme Court recognized in Novakovich, which is sort of the main case from Wyoming dealing with the no-claim statute, what they said was that a creditor's due process right to notice outweighs the state's interest in the sanctity of a closed probate proceeding. So again, when you look at this question, you have to look at it entirely from our point of view, not just even the facts, but any inferences you draw from the facts. You have to resolve all of those things in our favor. And if you do that, we would say that the conclusion is inescapable that there is a genuine issue of material fact about their knowledge as to whether she was either reasonably ascertainable or even a known creditor.
What are there cases that talk about the issue of? I mean, what I hear you saying is that evidence in the record that she had a claim at one point, but that it was resolved. I mean, that, as I understand, is the record. What case holds that that's enough to establish the opposite?
Again, not to disagree, Your Honor, but to disagree.
If I'm wrong on the record, tell me.
Yeah, the record does not establish that the claim was resolved.
No, but the record.
The record establishes that there were certain conversations between father and daughter about the claim, in which they claim that he said that I paid this, I resolved it, and if you look at this from the end of the timeline, these conversations occurred shortly before his death. First of all, why are they even discussing it at that point? And if they're discussing it at that point, surely she's at least a reasonably ascertainable creditor, regardless of how father might have answered the question. Because again, they make the point that the divorce settlement dates from 1987. If the conversation dated from 2014, I mean, I would say that weighs in our favor.
Have been talked about in context of she has a claim against the estate, but that has already been resolved. At the time of the discussion, I'm having a hard time understanding exactly what would have been said, other than at some point I had obligations to my ex-wife that have all been satisfied. Does it go beyond that?
I guess the record would say that that's the conversation in a nutshell. But
is that enough? I owed some credit cards before, but I've paid them all. Does that put the personal representative reasonably on notice to go look for credit cards if he says, I owed some credit card debt, but I've paid it?
The personal representative has a duty to pursue these questions with diligence, so I'd say yes, absolutely.
Under the statute, is a creditor one who is owed money, or is a creditor one that has been in a relationship with the decedent in which the decedent has owed her money?
I would
see the distinction I'm trying to draw?
Not clearly, Your Honor. I apologize.
No, I'm being unclear. Do we interpret the language of the statute about a creditor to mean one who is owed money, or does it mean one who has been in a relationship with the decedent in which the decedent has borrowed money, or to whom the decedent has owed money, may or may not owe?
I would think that the definition would include anyone to whom the decedent owes or may owe money. So may owe money. Mm-hmm. Okay. Yes, Your Honor. And again, looking at the standard for a summary judgment, and looking at all of the inferences here, it all has to be resolved our way, and the due process clause just adds added weight to that. And we would say if you resolve all of these inferences in our direction, you have to come to the conclusion that conversation raises a genuine issue of material fact about her status as a reasonably ascertainable creditor. She was entitled to notice, which she did not get. Are there any other questions on that issue?
If the testimony, if you go to trial and the only testimony is he told me that he had some obligations, but they have already been paid, you're just saying that we don't know what the conversation is,
well,
and you would still think that that's a factual question because she might not be believed. Is that your position?
Well, there was discovery before there was a limited opportunity for discovery. There was a document request that we propounded. It yielded two documents. One was the affidavit of publication from the probate. The other was a copy of the stipulation to the distribution. The request asked for all sorts of things, communications, documents, evidence, and communications about this debt, about the letter that Ms. Thorne's counsel had sent, all kinds of stuff. And so we would say, that would abide further discovery because we haven't had, we haven't taken depositions. We haven't explored either what the other two personal representatives have to say. The declaration was only from one of the daughters, not from the decedent's spouse, not from his other daughter. So all we're saying is that it's not enough to withstand summary judgment at this point.
So you would need affidavits from all, there were three personal representatives?
Well, yes, I'm not sure if we still have three, but one was his spouse, I think Mary Jo Evitt, and then Leslie Hiatt, his daughter, who provided the affidavit, and I'm sorry, I'm having a senior moment, and his other daughter. They're all personal representatives.
And are they living?
Oh, yes.
The other two?
All three. Yeah, all three personal representatives are living.
But the basis for your argument now is that one of them submitted something saying I had a conversation, but he said any obligations were paid.
Yes. Yes, Your Honor. I want to spend, I just quickly want to dispatch the notion before I get to the second issue. They say over and over again that we didn't make the claim, any claim in the Wyoming probate. That really is beside the point. We were perfectly entitled to open the probate here. And in fact, if they had told Dr. Thorne about the probate when her counsel wrote to them, we might just have filed a claim up there. But I know that's covered in our briefs.
Probate's still ongoing the first time?
I believe the Wyoming probate is closed. And we're here.
I'm guessing you would have done something to attempt to reopen it.
Well, we may have, if they'd have told us that there was a probate up there, we at least would have been notified of it. Perhaps we would have filed the claim up there. It's just not knowing anything about it. And actually, in keeping with what counsel said in the letter, he proceeded with a probate here, and under Arizona law, that was perfectly fine and a perfectly appropriate vehicle to deal with this claim. Now, as a matter of statutory interpretation, both the personal representatives and the trial court relied on a part of the ARS 143803A, which defines claims arising before the decedent's death. And they looked at that statute. They say these include contingent claims, claims due or to become due. This looks like a contingent claim, therefore it arose before his death. The problem is the words contingent and due or to become due in that statute do not help us because they also appear in Part C of the statute, which deals with claims that arise at or after the decedent's death. Same verbiage. So, it's a contingent claim. What does that tell us? And I think in this case, where part of the contingency is the decedent's death, you have to look at the question from that moment in time. And in point of fact, if you resolve it their way, because one of the things I think we're supposed to do is to try to give effect to all provisions in the statute. You resolve this question in the way the trial court did. You essentially erased the words contingent and due or to become due from this portion of the statute dealing at least with claims arising at the moment of death, if not after. Do it the other way around. Look at this as a contingent claim that arose at the moment he died. It does no violence to Part A of the statute at all.
And the other side, I cited some cases that interpret this statute to mean, the statute in other states to mean that it arises before death because the act is either done or not done before death.
Well, but
what's the best case for the other view?
Well, actually, none of the cases they cite really, because in each case, like the two cases that dealt with an analogous situation, one was the Florida Supreme Court. The other one was the Minnesota Court of Appeals, and both dealt with divorce decrees involving a promise to provide life insurance or to make payment upon the decedent's death.
Isn't this a promise? I've got the language here.
No, it's
agrees to provide wife.
No, in the other cases, the agreement was that he would do something to change his estate, to provide for her, it required further action by the husband. This is a self-executing provision once he predeceases her. In the other case, in fact, the Minnesota case, it hinges on the finding that the judgment obligated decedent to take action while living to ensure that appellant would receive $175,000 upon his death.
What's different from...
But in this case, there's no action. There's nothing that Mr. Evitt could have done that wasn't already done in that provision. There's nothing Dr. Thorne could have done to enforce that provision the way it was written.
Mr. Evitt could have put it in his will, or he could have bought a life insurance policy, right?
No, but the difference is the contractual provision. This is just an automatic payment. The other cases, they speak in terms of a commitment to provide for the person in the state, to actually take an affirmative action. This is both true in Florida, and it's true in the Minnesota case. A contractual commitment to change his will, to provide for future maintenance. That was Spohr versus Berryman, estate of Hathaway, the Minnesota case. A divorce decree directing decedent to either maintain the life insurance or alternatively to provide in some other manner for the tax-free payment of that amount to appellant within 60 days following the death. It required further action. Here, the contract requires nothing further to enforce it, and there's nothing that he could do to escape its operation, and there's nothing she could have done until he died to enforce it.
Under those cases, so you're saying nothing accrued until the date of death?
In this case?
Or in those cases, at a minimum, something accrued the day before he died because he should have changed his will to make a provision. In
those cases, actually, from the moment the contract was executed, the spouse could have tried to enforce that provision, to insist on it, the requisite changes, to make the arrangements that were called for by the contract. It's just much looser than this. Here, it's a mandate. It's automatic. If I predecease you, I have the life insurance option, but you get $150,000. And again, there's nothing that he could do to change it, nothing that she could do to enforce it. So in the other cases, I think properly analyzed, those do describe contingencies arising before death because there was still the possibility to take action. That's absent here.
Wouldn't she be able to do, I guess you're saying she doesn't need to. She certainly could ask to see a copy of the will, where you're just saying it doesn't matter because she's a creditor, because she has this document that says... Because
the document says pay this. It doesn't say arrange for payment, change your will to make payment. It doesn't say anything in terms of a future action by him other than payment. Or, life insurance was an option. And I see I have 3 minutes and 43 seconds, so unless there are further questions, I would like to reserve that for the rebuttal.
Good morning. My name is Daryl Manhart, and I represent Personal Representative Mary Jo Evitt, also known as Jody Evitt. She's currently the sole personal representative. In the trial court below, there were 3 co-personal representatives. Jacob Maskovich is sitting here at the table today. He represented the other 2 2 of the many daughters, the 2 who were personal representatives below. I'll be arguing for the appellee today. The 3 issues that I'd like to start first with. Society prefers that assets not lie dormant, that things be put to use. That's fulfilled in part of the policies of probate statutes, and non-claim provisions of probate statutes, which are to put those assets back into circulation or use, which is why you have across the country statutes, systems that require or provide for expeditious processing of probate so that they're not tied up unduly for a long period of time.
But under their theory here, at least if it's a self-executing document, you don't have a 6-year, which you would have under a contract provision. It's more limited under the probate statutes. It's 2 years. Is that right?
It can be 2 years, Your Honor. The way they generally work, which is summarized fairly concisely in the Tulsa Professional versus Pope case by the Supreme Court, which is you have the statutes generally work where there's sort of two different things operating. If you're measuring from date of death, it varies apparently from like 1 to 5 or 6 years across the country. It's 2 years in Arizona. There's also measurement from notice, whether it's the published notice
But all
or
I'm
actual
getting at
notice.
is they're not suggesting that it would be 6 years. They're acknowledging it's 2 years.
Correct.
And that still satisfies the desire to having more, to get things resolved.
Correct, Your Honor. If Judith Evitt Thorne is a reasonably ascertainable creditor, then she was entitled to 2 years to bring her claim because she did not receive direct notice. She only received published notice in Wyoming. And that's their first issue, claiming that she should be treated as a reasonably ascertainable creditor. And I'd like to address a couple of things there. One is procedure, or the reason that this court exists, which is to review the lower court. And that's an argument I made in there, that this argument's not been preserved. On summary judgment, which is the only issue presented in their opening brief, they're challenging summary judgment. The case law is that you have to have presented that to the trial court before the ruling on summary judgment. The argument that the declaration filed by one of the personal representatives that she had some communication from her father about the prior indebtedness is in that declaration filed with the motion for summary judgment, and that's ignored in their response to the summary judgment. It's only in their motion for new trial that they make that argument. That's too late. That's waived. That means on review, this court decides the Superior Court correctly decided that issue. But if I go now to the merits of it, too, it's not meritorious. The burden is upon the person, the proponent of the claim. It was the burden of Judith Evitt Thorne to provide evidence that she was a reasonably ascertainable creditor. You can look at the cases that are cited in the brief. Novakovich, Soriano and Spears all treat it as the proponent of that claim. They're looking at the evidence presented by that person. Judith Evitt Thorne presented no evidence that she was a reasonably ascertainable creditor. The belated argument that she makes in her motion for new trial relies completely on the declaration of Leslie Hiatt, and counsel did not quite tell you everything that's in that declaration. Paragraph 14 is the one where she says, on multiple occasions prior to his death, I specifically recall my father telling me that he no longer owed Ms. Evitt Thorne anything, and that any obligation he had to Ms. Evitt Thorne had long ago been paid in full. He described that as discussions. They're just statements she's reporting. And then the very next paragraph, he tried to characterize it today as if these are discussions that occurred near death, and said it was not known how long ago. And the actual date isn't known. But what she said in paragraph 15 was based upon how long ago my father had divorced Ms. Evitt Thorne and his statements to me years previously. At no point did it ever occur to me, nor did I ever contemplate, that Ms. Evitt Thorne was a possible creditor of the estate. So we have something that's years previously that she's reporting on in support of the summary judgment, nothing stated as evidence that this was something during the period that the personal
She doesn't use the terminology, this claim. The language that you've cited is the only language that she provided.
Correct. I read from verbatim there from the declaration.
What do the cases tell us about? I mean, claims are always often claims are disputed. That's why we have courts. So, what do the cases say about the question I was asking before, which is the reasonably ascertainable creditor? Does that mean one who has been in a creditor relationship in the past, or one that is actually owed money? How do we know what?
It would have to, between those two would be the latter, Your Honor. If again, you can look back at the Tulsa Professional and Pope case, and it cites Mullane, an earlier Supreme Court case, which had slightly different facts. But those talk about creditors who are reasonably ascertainable or actually known, and they distinguish ones where they're conjectural or future claims. And as to those, they say published notice is sufficient. If you look now in the sort of cases that involve this, which they're not a whole lot, but the typical way a person would show they're reasonably ascertainable is something, for instance, regular billings being sent or a record of regular payments being made. So here there's no evidence of any communications that I'm sorry, I didn't know she was a doctor. Dr. Evitt Thorne had presented over years keeping contact with her ex-husband. There's no evidence of payments. I understand that the provision, you wouldn't expect there to be payments, except for the disputed argument we're not addressing here today. But there's no evidence presented of that. So there's nothing that Dr. Evitt Thorne presented on her burden of persuasion to show she was a reasonably ascertainable creditor. She only relies upon this statement by one of the daughters that years previously her father had said she'd all been paid, and wants the conjecture to be, because my father said he'd previously paid her, she should have assumed maybe she really still was a creditor.
And meaning she should have assumed that that a creditor relationship continued and what she had heard from her father was false.
Right, but that's conjecture, Your Honor,
Yeah.
and that's not consistent with what the two U.S. Supreme Court cases say, the situation for where you would have to give specific notice, because that would require, rather than expeditiously process a probate, a personal representative would have to go through and find everything that deceased had ever owed money on long ago, car loans, house loans. If you knew that there was a promissory note that had a maturity date 5 years before death, you have to go find out, was there something you didn't know that it was extended, even though there's nothing in the records that say that? That's not the burden on the personal representative. The burden is to only make a reasonable review. There was evidence here of that. Again, the same declaration says it actually says that the personal representatives, it's plural, but that the one declaration says that they went through the business records and they spoke with his accountant to see what his business obligations were, and they did not discover that there was any obligation to Judith Evitt Thorne. They did discover 2 potential creditors, and they gave them notice. That satisfied their duty. It shows, though, that there is no evidence to support the burden of persuasion of Judith Evitt Thorne that she was a reasonably ascertainable creditor. And if she's not a reasonably ascertainable creditor, her claim in Wyoming was barred. And I'll move on to the next, the statutory, bring me back to the reasonably ascertainable if you need to. On the statute, I'd like you to make a comparison of the two statutes. What I did was I put them in 2 columns next to each other and then separated the language that was the same and what was different. It really highlights something. You see the arise at death in Part A and arise at or after in Part C. And most of the rest of the language is is the same with a few distinctions. One of the things that opposing counsel points out is that string of words, whether due or to become due, absolute or contingent, liquidated or unliquidated, founded on contract, tort, or other legal basis. That appears in both of those. When he talks about you have to construe the statutes as a whole, yes, do that. And when you look at that, that tells you that those words tell you that it doesn't mean accrue. That would be something like due or to become due. Due is accrued, to become due, something hasn't happened yet to make it come due, like a promissory that hasn't come due yet. Those words show you that that's distinct from the words that precede that, whether the claim arises at death or arises before death. So the very argument they're making here is to equate arise with accrue. That's not what it means. You can tell that from the statutory language. If you look at a prior decision of the Court of Appeals in this state, Ader versus the state of Felger, it specifically looks at those two parts of the statute and says arise doesn't mean the same as accrue. It means originates. What are the acts or events that give rise to the claim? And that's what we have here. The acts or events that give rise to the claim are the July 1987 settlement agreement that's been made part of the September 1987 decree. So those things are years and years ago. That arises before death. The distinction that counsel made today, too, is he argues that somehow that the...
But was there a claim that that Ms. Evitt Thorne could have raised the day after or a week after when the claim arose under the definition we're working with here? you're saying that a claim arose. What could she have done at that point? Could she have filed something to say you have to revise your will, you have to get an insurance policy? Or their argument now is, well, I don't need that because I've got this document that I can present when he dies. But in your view, would she have a claim? Sorry for the rambling.
Well,
question.
I'm sorry, Your Honor, but I'm going to disagree with your premise that that's the way you're supposed to interpret that language. No, she could not have made a claim or sued, if that's what you mean by make a claim, prior to his death. But
you're just saying the claim arose from
that's right.
The agreement.
In the Uniform Probate Code statute, arise before death or arise at or after death is talking about those events and tells you when you have to, it tells you which part you're governed by and when you need to submit your claim. And if you look, and I'm sorry, I didn't find, maybe I didn't go back in time long enough. I didn't find a lot of cases that talk about the arise at or after, sort of the policy or reason behind it, but I did parenthetically, I think, made a couple references to what I'd seen in some cases, which those are really designed to cover the situation of things that happen either like the last expenses of death, like there was was a gentleman who died in the hospital and the claim was for those services then because they still have the body there and they have to do something. There was also an example of some cases that you might have income that comes in after death, the investments that the deceased had. That statute about arises at or after is meant to cover those and things that the personal representative does. So those are governed separately. Most claims are going to be arise before, even though they may be contingent in a way that they don't become due until death. They arise before death. And I gave examples of 3 Uniform Probate Code state cases that showed that that's the way that's interpreted. We're a Uniform Probate Code state as well. There's no case he has in his brief that shows you anything to the contrary. His whole argument is look at the statute and arise at or after must mean the way I say it means, even though I've pointed out why it should not.
In those states, there was a requirement that someone do something before, that they were obligated to go change an insurance policy or to get an insurance policy, or there was a promise that isn't necessarily present here?
I'm sorry, Your Honor. I want to be respectful. Your question is wrong. They don't have to do anything. It's just the event arises. So
I'm just giving you what I think his argument is.
I'm sorry. I think, and I apologize, I said the question is wrong. The language in that they quote, that we both quote, says that he was to provide $150,000. So he was supposed to do something. He had an option that was given like that could have included providing insurance, but otherwise it says the presumption would be, I guess, he has to provide in his will. He has to provide somehow. So it doesn't say upon death his estate will owe $150,000. It says husband will provide $150,000. As far as the claim, claim is referring not really, maybe I should say it's a noun and not a verb. Judith Evitt Thorne wasn't supposed to do something, except when he died, she was governed by the probate statutes, and she had a time period to submit a claim. The events upon which her claim were based were ones that originated before death. Therefore, she was governed by the part that said she had to submit something, that she was governed by Wyoming was 3 months to submit her claim, and if she fails to do so, then her claim is barred. Then when she files a claim, starts an ancillary probate in Arizona and wants to submit a claim, our statute says if what the claim is based upon arises before death, then you're barred if you're barred under the non-claim statute of a domiciliary probate. And she was barred by the Wyoming probate, and therefore her claim is barred in Arizona.
So in that scenario, the former spouse needs to, if there's no evidence that she's reasonably ascertainable, and maybe there was, maybe there wasn't, but otherwise you need to keep track of where your former spouse is.
Yes, Your Honor, and Ader says that, and I cited some cases from some other jurisdictions too that say that it's the burdens on the creditor to keep track of your debtor. Again, the opening brief tries to manufacture some sort of equitable notion that she shouldn't be held at fault for not making a claim because her ex-husband's family didn't tell her that he had died. But that's based upon the non-existence of any obligation to notify anybody, except ascertainable creditors. So it was her burden to keep track of her ex-husband if she wanted to make this claim, and she didn't do it, or she eventually learned, but not within sufficient time, and so she didn't make a claim in Wyoming, and her claim attempted here in Arizona was untimely.
If that equitable doctrine does apply, we didn't talk about that in the opening round, but if that equitable doctrine does apply, what does it give to a claimant? Certainly doesn't extend the time to make the claim infinitely.
Well, Your Honor, I mean, my first notion on that is I don't know why, since it's a Wyoming statutory provision and we're talking about the Wyoming domiciliary probate, I'm not even sure that Arizona is the proper place for that argument to be made.
Okay.
And again, that argument also was not made in the written response to summary judgment. I do acknowledge that at oral argument in summary judgment, there's the first reference to it to which I can't remember if it's Mr. Maskovich or his partner, but counsel at the argument said, I'm hearing this for the first time. So and I cited a couple cases that I think suggest that that's not good enough. That's waived. It is in the motion for new trial. I'm arguing, though, that even if you don't agree with me that it's waived, they haven't shown peculiar circumstances. If you look at the statute and you look at the Wyoming Supreme Court case addressing it, Scott, it's talking about whether the circumstances equitably justify the person's failure to have timely made the claim. So we're talking about that window back in the 3 months during which a claim could have been in Wyoming. What was there that equitably prevented Judith Evitt Thorne from making that claim? All the things she lists are things like, when we got to Arizona, the judge said, why don't you guys try to work this out? We're already here.
But if it's proved, and I understand your argument is, what does it give a claimant? How long does it give the claimant to file?
Well, there's really not any case law I can point you to. The statute doesn't say, and the I can't remember if it's, I think Noskovich and Scott are both cases that refer to that Wyoming statute. Those are Wyoming cases. They don't set a time limit. I suppose since it's equitably, it's stated the statute itself is based upon whether it's equitable to do so. The court would, in that case, be governed by equitable principles and laches.
In fact, one of the factors might be how long you waited.
Yeah.
Right.
For as long as it is equitable to.
Right. But again, besides I'm arguing that they did not preserve that, they also don't present any equitable factors. There's a laundry list of things there, and they all really are not timely, I mean, not focused on the correct time in which you would want to look for what are the circumstances, and they're not things that are out of the ordinary. Not knowing your ex-husband had died is going to be probably the most ordinary of reasons for somebody to be making that claim. You have to show some reason, like there was some reason I was not able to keep track. And I see my time's up. Thank you very much.
Could you start with the reasonably ascertainable argument, and in particular, what statement you're relying on from the personal representative?
It's in paragraph 14 of the statement. He read it to you, and I do stand correctly. Nothing more than that. But again, and what he loses sight of is we're talking about all these issues in the context of a summary judgment, where regardless of the ultimate burden, all of the inferences against summary relief cut in our favor, and the due process clause just adds the weight to that. But that's the statement that we are relying on. But I will concede that the next paragraph does say years previously, and so I want to correct myself on that. As to assets lying dormant, his first point, Novakovich, states that the creditor's due process right to notice, if the creditor's reasonably ascertainable, trumps any of that stuff. It comes before any of those considerations. In the notion about that our opening brief, our notice of appeal covered the summary judgment motion, the motion for new trial. our opening brief, it did focus on the summary judgment motion, but the law actually is that you can't use a motion for new trial to come up with a brand new defense, a brand new legal theory. And actually, like the cases they cite, one of them was a dispute over mandatory vaccinations where the plaintiffs hang their suit on the Arizona constitutional provision for a public education. And then in the motion for new trial, they raised for the first time, well, wait a minute, you also infringed our religious liberty, our right to privacy. These are brand new ideas. We don't have any brand new ideas in our motion for new trial. It's just, it's the same argument we've been making all along. She is a reasonably ascertainable creditor entitled to notice. And then also, with respect to the Ader case, that actually turned on the fact that there was no personal representative appointed in that case. And so by the time the claim arose, there was no power to do anything with it. It just doesn't hinge on whatever language they're relying on. The same goes for Scott, or actually in Scott, the creditor got notice and did nothing. It's nothing like this case. Because, as the court said, the creditor received notice, the creditor didn't file a claim. And so, again, in terms of what actually amounts to equitable release, I guess we have dictum from Wyoming, but we don't have an actual holding on that point. I think equitable relief is a broad concept, and, we went through the factors. Actually, at the oral argument, I handed counsel and the judge the statute, and I went through the factors, point by point, in the oral argument, at least on the motion for summary judgment before raising it in the motion for new trial. You already made the point that obviously there would be no payment history here because the agreement called for a lump sum payment, so there would be nothing like that, no correspondence, no reason for any of those things in this case. It just directed him to provide $150,000 to her if he died first and she died second. And again, we would say if the contingency is the decedent's death, you have to look at the question from that standpoint. Otherwise, you write that language right out of the C part of the statute. If you look at it that way, you've erased the provision for claims arising at the moment of death.
Thank you.
Thank you.
Thank you to both sets of lawyers for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.